Very warm greetings to all of you. Hi, I'm Dikshika Tripathi and I work as a human rights activist for All India Human Rights Association. And today we will discuss about the difference between judicial review, judicial activism and judicial overreach. Let's begin with judicial review. Though legislature has the power to make laws, this power is not absolute. Judicial review is the process by which judiciary reviews the validity of laws passed by the legislature. So, from where does the power of judicial review come from? It is driven from Article 13 of the Indian Constitution itself. Article 13 of the Constitution ये प्रोहिबिट करता है पार्लियामेंट और स्टेट लेजिस्लेचर्स को ताकि वो ऐसे कोई भी लॉज ना बना सके जिससे कि एक इंडिविजुअल और एक इंडियन सिटीजन के फंडामेंटल राइट्स का वायलेशन हो. The example of judicial review is the striking down of Section 66A of the IT Act as it was against the fundamental rights guaranteed by the Constitution. Moving on to judicial activism. Judicial activism denotes a more active role taken by the judiciary to dispense social justice. So when we speak of judicial activism, we point fingers to the invented mechanisms which have no constitutional backing. For example, suo motu cases, public interest litigation, and new doctrines, etc. So, from where does the power of judicial activism come from? It has no constitutional article or no constitutional backing to support its origin. It was a precedent set by the Indian judiciary, and there is a similar concept followed in the United States of America. The most common practice is suo motu cases. सुओ मोटो केसेस में क्या होता है कि जब भी कोई जुडिशियल ऑफिसर या कोई जुडिशरी किसी पब्लिक इशू में इंटरवीन करके खुद से ही कोई स्टेप ले तो वो सुओ मोटो केसेस होते हैं. For example, the invention of the basic structure doctrine in the Keshananda Bharti case, by which the Supreme Court further extended the scope of judicial review in corporation of due process of law instead of procedure established by law. The collegium system and the institutionalization of PIL, that is public interest litigation, and now judicial overreach. So the difference between judicial activism and judicial overreach is very narrow. In simple terms, we can say that judicial activism crosses its limits and becomes judicial evangelism, and that is known as judicial overreach. Judicial overreach, just like judicial activism, is not defined in the democracy and it is an undesirable feature because it destroys the spirit of separation of power. An example of judicial overreach is what makes any action activism or overreach is based upon the perspective of individuals, but in general, striking down of NJAC bill and the 99th Constitutional Amendment, the order passed by the Allahabad High Court, making it compulsory for bureaucrats to send their children to government school, misuse the power to punish for the contempt of court, etc., are known as judicial overreach. So to sum it up, judicial review is it has a constitutional backing under Article 30. The main purpose was to check the parliament so that it doesn't take any steps which are not in consideration of the fundamental rights of the citizens. And judicial activism it does not have a constitutional backing, but it is a suo motu cognizance on a PIL that is taken by the judiciary itself for the betterment of the society and to correct the wrongs that have been taken. And judicial overreach is something which crosses all the boundaries of judicial review and judicial